Good afternoon, everyone. It's just about 4 o'clock, so we will make a start. I hope you've all had a good week up until now, and that you are staying alert and remaining safe and healthy as well. So this afternoon specifically, we've invited Wrigleys Solicitors, who we work with, along to look at issues around confidentiality, data regulations, freedom of information request, and data subject access request. Now, this was in response directly to a previous update we did with Dylan William and Chris Baker, looking at the process of teacher assessment and ranking, or centre assessment grading, as it's referred to technically. And you can watch that video on the SSAT blog. In that update, Dylan mentioned the fact that obviously schools need to be very aware of the data regulations related to this process, and the fact that if in the case that you have an FOI or a subject request for that data, then you do need to pass that over, including any documentation that relates to how that decision was made, which is why we're really pleased that Chris Billington can join us this afternoon to talk through that. Just as a quick reminder for you, obviously all of you at the moment are in the middle of the process of centre assessed grades, which will be submitted from the 1st of June. And essentially, we're seeing that as a 5-part process. The first part being the teacher assessment, the second part being the ranking exercise, where you rank every student entered for that qualification, regardless of the year group, into one rank per grade. Thirdly is the submission and any potential moderation that the exam boards do. Then we have the standardisation, which takes account of 3 things: your school's prior attainment, national grade distributions, and the prior attainment of your cohort as well. And then that will result in the final calculated grade. And then finally, of course, we have the appeals process and potentially the autumn series, where students who aren't happy with the grade they've got will be able to resit. All of this is set out, including our own guidance from SSAT in a guide on leading this process for school leaders that went out in the Sunday supplement this week, and a link to that is in the chat function of this Zoom meeting. Please do use the chat function to ask Chris any questions as we go. Myself and my colleague Mike will be on hand to moderate those questions and to ask them as appropriate, either during Chris's presentation or indeed in the Q&A afterwards. But please do use the chat function as we go to do that. But I'm going to bring in Chris now and ask him to go through his presentation, looking specifically at those issues around confidentiality, data regulations, freedom of information and data subject access requests, and what you need to be aware of as a school if this is a possibility in the summer. So Chris, I'm hoping that you're there.
I am still here, thank you. I was just checking that I've been brought off mute, so thank you, welcome all. As Thomas mentioned, my name is Chris Billington. I'm part of the education team at Wrigleys. I'm not proposing to go into too much detail in relation to the centre assessment work. As Thomas mentioned, that's already been picked up in a previous session and it's available through the SSAT blog. But I do just want to set something of a framework around the different access routes that parents and carers have in terms of seeking information from the school. So these are the areas that I'll be quickly covering. I propose to talk for about 20, maybe 25 minutes at most. Hopefully Tom will cut me off if I get too excited and carried away on data protection issues. Then we move into a Q&A session, but please do, as Thomas mentioned, get your questions coming in, and hopefully we can then delve into some of the more detailed, more practical issues as part of that Q&A session. So just very quickly, if I may, I just want to flag the requirement that falls to the subject teachers and the assessment centres as part of the process that we are working through. It is important because any challenge that comes in will be based around the question of whether or not you have done what you need to do as part of the exceptional circumstances that are being applied through this year. The text here is simply taken from the Ofqual guidance. We do know obviously that Ofqual are out in consultation in certain areas and expect an update next week from them, particularly around the question of any appeal process. I'll touch on that very briefly in a later slide. Key point to flag is very much that the assessment is very much a professional judgment, balancing the evidence that's available to you with the guidance as referred to already, setting out some examples of the evidence that you need to be taking into account. It's also important just to bear in mind that the centre assessment grades are just one part of that process, and there will be a supplemental stage undertaken by the exam boards, again in accordance with guidance that will come out from Ofqual following the recent consultation around some kind of standardisation, moderation of those results. That has a particular relevance to individual assessment centres and teachers involved, and because they have been clear in the guidance to date that they will use that process to, in essence, adjust the grades that you have assessed where they feel that that is out of keeping with the statistical standardization process that they are currently fine-tuning. And that does mean to say that should there be any challenge, then whether or not the centre assessment grades have undergone a moderation process could be relevant in determining whether or not each centre has gone through a robust enough process to objectively evidence the assessments that they have been submitting. Just a quick flash, exam malpractice, it does exist. We do understand that this system, whilst exceptional, may be subject to influences. Again, just a caution that it is a professional judgment matter. So in terms then of the framework, reference is clearly made to data protection and the rights, particularly the right of access through the data subject access requests. But there are two other regimes that we just need to have in mind. The first is the Education Pupil Information Regulations, which apply to maintained schools. It does not apply to academies. Through the process, written request is made through which the school will need to allow inspection of the educational records. There is some uncertainty as to whether or not the educational records would include the process that the process that the assessment centres are currently going through in terms of the exam grade assessment work that is being undertaken. It is unlikely, and my recommendation would be that should any request come through these regulations, then they are put on hold and dealt with simply as part of the data protection regime, which I'll move on to in a moment. First, freedom of information. Now, there is a clear separation between freedom of information and data protection. That line lies in very much the exception under freedom of information to any personal data. However, the work that you're doing through assessment will include both the guidance that comes from Ofqual and the exam boards in terms of the assessment process, but also the internal assessment mechanisms and frameworks that you have established within your individual schools, which is designed obviously to give guidance, further comfort to teachers about how they in practice deal with the available evidence, but also some of those wider-ranging discussions around what assessment means in practical terms, the dividing line being that once your assessment turns to the individual pupil, you shift over into personal data, and that element of the assessment is going to be subject to the data protection regime. But it doesn't mean to say that freedom of information is not relevant, because, as I say, a lot of the information you will be starting with and the framework that you are establishing, which won't be personal data, will fall under the Freedom of Information Act. A request, again, a written request comes in, the time period relevant, and I'm afraid we do talk about different time periods under each of the different access routes. The time frame under freedom of information is 20 school days, or if shorter, 60 working days. There's no relevance to that time frame when we start talking about the results day. But having said that, there are, again, exceptions to freedom of information. I've touched on the personal data element. Other ones which may be relevant would be a time constraint, if it would take you more than 18 hours to deal with a particular request. We are not expecting that that would apply to the process that you are working through at the moment. Because again, remember, this is the collation of the evidence, not the working through the assessment process itself to achieve the assessment outcomes, the assessment grades that you are being asked to provide. A key exemption is that the information is already available. Now, that can be because it's been made available through Ofqual itself. A lot of the guidance that they have issued to schools is already on the website. It's already in the public domain. If you get a freedom of information request that touches on anything that is already available, then you don't need to answer it again. In terms of it being already immediately available, that does lead us into one of the early steps that we can take to anticipate requests coming in, and that is to ensure that there is a clear communication channel between school and parents and carers, so that they understand the framework that you are working under, not obviously the more detailed conversations, but as I say, that separate framework that would otherwise fall under freedom of information. And that as part of that communication channel, you make available to parents and carers the relevant links to the guidance that's in the public domain. In that way, you don't have to do it again. Should they ask, you can simply refer them to your previous answers. There's an element in terms of exemption for confidential information, but unfortunately this is not going to cover the information that you are generating within school as part of your assessment process. This is confidential information that is received into school from third parties, which due to that confidential nature, it is not appropriate to share under a general freedom of information exemption. The final exemption under freedom of information is that there is an intention to publish. Many public authorities, some academy trusts, some schools have a published publication policy. This isn't in terms of or following the results day, you would intend to publish the results that have been awarded, because here we're talking about the assessment material and the processes that you are applying as part of your assessment work. There is, I expect and anticipate, absolutely no intention to publish that. So again, it's care to be taken in terms of which elements of freedom of information are going to capture the information that you have, the information that is being sought by parents or carers as part of their request. So freedom of information, as I said, it deals with the framework, the guidance that is available rather than the specific detail that is applied to the individual. We then get to the Data Protection Act, which is the act which effectively introduces the current version of GDPR. And again, the process under the Data Protection Act will follow the same route, a written request. We do need to be clear that when a request comes in, it doesn't need to express itself as a request, whether it's under the Pupil Information Regulations, whether it's under the Freedom of Information Act, whether it's under the Data Protection Act. When you get a request in, if it is asking for information, it is then for you, working with your data officers, to determine how to respond to it. And a written request can come in via email, it can come in via text, it can come in via hard copy letter. It simply has to be recorded. And under the Data Protection Act, a data subject access request would ordinarily need to have a response within 1 month. But there are specific provisions that apply in relation to exam results where, somewhat perversely, if the request for access is made before the results day, the time limit for responding is whichever is going to be the shorter of 5 months from the request or 40 days of the results day. In some respects, someone who gets in early and makes a request before the results day is disadvantaged, because a response that comes in immediately before the results day, you would not need to respond to until 40 days later after the results day. But a request that came in immediately after the results day, you'd have 1 month. And 1 month is assessed as 1 calendar month. So it's not the 30 days, it's purely whatever the calendar month may be. Data Protection Act includes a number of rights. We're focusing very much on the right to access. There are other rights involved, and I just want to flag a peculiar point under the right to restrict processing. I only mention it because I have seen it used in other situations. In essence, should you receive a request to restrict processing, you are required to stop processing personal data relating to that particular individual. Now, clearly that would interfere with your assessment process. The right to restrict processing should set out grounds why the individual is objecting in some way to the processing that you are undertaking. My recommendation is that should you receive one of those, obviously you're going to be talking to your data officer as part of this process. But in order to avoid any delay to your assessment process, you need to respond immediately to bounce the request, to make it clear that you don't accept the objections that are being raised and that you are not proposing to agree to restrict processing. Now, that may itself lead to a complaint, but nonetheless, the time it takes to deal with that complaint will push it beyond the processing time that you will need to complete your assessment process. There are some particular provisions within the data protection legislation that deals with exams, exam scripts in particular, the written responses that candidates provide as part of the exam process are not subject to data protection. They do not have to be returned or disclosed. The exam results and the marker notes are subject. The restriction is the point that I made previously in terms of the extended timeline that only applies to a data subject access request that is received by you before the results day, which, as I say, gives you an extended period in which to respond to the request. Post results day, normal data protection rules apply. You are required to make your response. Now, as part of the response, there are 3 parts that are essential. Most will simply recognize the middle point, which is to provide a copy of the personal data. There are 2 other requirements under a response to a data subject access request. The first is simply to confirm that you are processing their personal data. And the third is to provide supplementary information, a big long list of information that you are required to provide, which confirms, in essence, the lawful basis upon which you are processing, the type of data you are processing, and other matters which should already be a part of your privacy notices. So provided that you are reasonably up to date with your data protection compliance, dealing with the first and third of those shouldn't be particularly difficult for you, but it's important to remember that those are part of the required response. So the key element that we come to is very much then, well, what is it that we are required to disclose as part of a data subject access request? What is personal data? This is the legal definition, information which is related to an identified or identifiable actual person. Natural person simply means that they are alive and living, therefore it does not cover those who have deceased. It does not cover corporate entities, companies and the like, but it will cover your pupils and your students. But the information has to be related to, and again, this is an area that does cause some confusion when dealing with a data subject access request. For example, a list of names of individuals who may, for example, form part of a particular year group or tutor group does not necessarily satisfy the personal data. Simply because somebody is named in a document does not mean to say that the information in that document relates to them as an individual. This is, as I say, part of the complexity of the data protection regime, and it does need some assessment of whether or not the particular information you have is required to be disclosed. What is included? As I say, everything that relates to the individual data subject. It has to be recorded in some form. It doesn't matter whether it's electronic, hard copy, or any other. If you decide to use some kind of code to try and disguise conversations, discussions, and decisions being taken in relation to individuals, if it's recorded, it is captured and it will need to be disclosed. And that does include something that you thought you may have deleted. The note here just refers you to your school's data retention policy. If you are deleting data which doesn't comply with your data protection policy, then you do have to ensure that the efforts that you are taking to identify and to locate the data are robust. And that does include shifting through deleted boxes for emails. It may even include having to scour old archived data hard drives. So if you have it, if it's in your possession, under your control, then it falls under the information that you need to disclose. We may wish to discuss some of the more practical issues around what that means and in terms of the way in which you are undertaking your assessments as part of the Q&A sessions, which I assure you is coming up very soon. Privacy notice, as I've touched on, this is something you should already have in place. It includes required information that will form part of a response to a data subject access request. So what happens then in terms of the assessment process that we are undertaking? Dealing first with the complaints process. If you get a request under freedom of information, data protection, there's no requirement, but it is good practice to have a complaints procedure. But in any event, as schools, there are statutory requirements around having a complaints procedure, which will cover a situation where you have an objection in that you have not properly complied with your freedom of information obligations, your obligations under the People Information Regulations, or indeed under data protection and subject access requests. The Information Commissioner's Office will expect you to deal with complaints first, and your normal school complaints procedure is perfectly well placed to assist you as part of that. As I say, for maintained schools, the requirement for complaint procedure is part of the Education Act. For academies, it falls under your funding agreement and obligations that link you through to the independent school standards regulations. Appeal process. At the moment, we know that the Ofqual guidance confirms there is no appeal on the assessment grade or ranking that will be applied, but there is reference to an appeal on a procedural failure. We're still awaiting some detail of what, and hopefully that will come out as part of the Ofqual response to their recent consultation. We're expecting their responses at some point next week, I believe, the 22nd. What sort of claims, obligations, objections can come out of this process? I would say these are essentially the same that you would face in any normal year in terms of disappointed pupils, disappointed parents and carers, and the challenges that they may seek to make to you either individually or through the school. Negligence, breach of contract, exam malpractice claims, as I say, these have all been dealt with previously. If they come in, your school will have systems and processes to deal with those. You will be calling in your insurers, and you'll be dealing with those in the ordinary way. And that extends also to any suggestions that individual teachers, as part of this process, have failed to act in accordance with their professional standards. Again, these issues are not new. The current exceptional circumstances and the way in which the assessments are being undertaken this year does provide new ground for complaints and claims to arise, but the expectation is that those would be dealt with in the usual robust manner that any assessment of grading undertaken as part of an examination process would normally be dealt with by courts and tribunals. That said, I think the distinct likelihood is that frustrated students, parents and carers are more likely to present a claim, if at all, because they feel that there has been a breach of the GDPR data protection regime, in particular in the way in which the school has dealt with a data subject access request. As I said before, it's hopeful that you are all reasonably compliant with existing data protection obligations, because if you are not, then a data subject access request that doesn't give satisfaction as part of this assessment process is likely simply to trigger a complaint being made to the Information Commissioner's Office that other aspects of your data protection management is not in place. For example, insufficient privacy notices, perhaps an emphasis within your data management regime on consent for information in terms of what you do, where consent is not perhaps the most appropriate legitimate basis for your data processing. So issues that are triggered perhaps by the current assessment process, but I'm afraid not particularly relating to it, because there are few channels for disgruntled and frustrated pupils or their parents and carers to take a complaint through the data protection or freedom of information angle against either individuals or schools. So some takeaways for you, briefly summarising the points that I have been quickly trotting through. You will create personal data as part of this process. There is no way to avoid it. I've heard suggestions that if you try to anonymise the data, can you avoid the data protection subject access requirements applying? I would have to say that is exceedingly dangerous, simply because if you're not being clear about which individual pupil you are talking about as part of your assessment, and you're talking in code, the scope for confusion and mistakes to arise is likely. if you start referring to people such as pupil A, pupil B, pupil C, etc., then the likelihood is that that would, in any event, still be subject to the data protection rules, because it's not just having someone's name on a piece of paper that necessarily identifies them. It's whatever kind of coding system that you may well be using, which will also bring them under the remit of the personal data regime. In terms of the confidentiality point, as I say, there is sufficient strength within freedom of information, within the pupil information regulations, and within data protection GDPR, that you do not need to make any response concerning the assessment process or the assessment grades that you are making until after the results day. But after the results day, that information will be subject to the data protection regime and subject access request, so be prepared. In terms of the assessments themselves, the key here is to have confidence in your professional judgment. If they are being challenged, then that's slightly separate to the question of whether or not you need to disclose what they are in the first place. But nonetheless, ensuring that a robust process has been followed will deal very much with many of the issues that are going to be flagged behind the data subject access request requirements. So a very quick trot through the data protection and related information access regimes. I'm going to open up for Q&A, and I'd invite Tom and Mike just to flag up any questions that have come through as part of that process. Over to you, Tom.
Yep, thank you. We've had a couple of questions in, Chris, and I'll give Mike a moment just to process those. But also, if people have additional questions, please do post them in the chat or put your hand up, and we can bring you in live. One question I've got is a question that we've been asked a lot, which is a lot of schools are, particularly around the ranking exercise, more than teacher assessment, are doing this over an online meeting, say like this, over Zoom or Teams or what have you. They're not recording it, and so they're going through and they're deciding as a team where particular candidates are in each rank. If that's not recorded, do you need to record that, and does it need to be passed over if there is a request? And secondly, if you don't record it, is it legitimate to say, well, no, that was behind essentially closed doors. We had a discussion around this, and we didn't record it. Would that be appropriate?
Yes, to the question you've posed. There's two separate elements to that. First of all, if it's not recorded, then it's not going to be disclosable as part of either freedom of information insofar as the conversation is a wider conversation about processes and procedures, or in relation to a data subject access request, because there is no record as the conversation is taking place around the particular information relevant to an individual. The outcome of those conversations will be recorded. That information will form the personal data that will need to be disclosed in relation to any data subject access request. There's no legal obligation to record those conversations, just as there would be no legal obligation to record a meeting that took place in person around a table. However, the flip side of that is that as part of the assessment process, you're being asked to evidence a robust procedure. The recording would assist that, but it's not essential for that, because if you can confirm that you have had that meeting, whether it's Zoom or whether it's a face-to-face meeting as social distancing rules would allow, then you are producing the evidence as to the robustness of the process that you have gone through without somebody being able to actually listen to what was discussed or see a transcript of what was discussed.
Great, thanks, Chris. So we've had a couple of other questions in. So one question was, what constitutes a formal either FOI or data subject access request? If it's a parent writing an email just saying, I would like to know my child's teacher assessed grade and their rank order, does that formally count as a request?
Absolutely. And again, this is one of the difficult areas for individual members of staff, but also for data officers having to deal with the request. Anything that asks for information will satisfy both the freedom of information and the data protection requirements for a written request. It can be completely obscure so long as there is that request for information in there. It then triggers an obligation for you to determine what regime you're working under. But if there is any confusion for you as to the scope of information that is being sought, then the obligation is very much on the school to go back to the parent and say, can you please clarify what it is that you are looking for? Your time limit for providing the information will only though start running once you have got that clarification. So that's the saver for you as part of something that is not as clear as you would want. But again, there is no form. You cannot oblige anyone to use a particular form that might be available on the school website. It does not have to refer to freedom of information. It does not have to refer to data protection or GDPR. It is simply a request for information that relates to an identifiable individual. In particular, clearly it's going to be that person's child. If those elements aren't there, the request for information relating to an individual is not going to fall under data protection.
Thank you, Chris. In terms of, just thinking aloud, in terms of the parents and the students, we're talking a lot about both students and parents. In the case of, say, GCSE students who are under 18, can parents put in a request on behalf of their child? If it's an A-level student who's 18 or over, does it have to be the individual students?
The old test was very much a case of maturity of the child, and the indicator that has been used by the Information Commission Officer for many years is age of 12. Above the age of 12, provided you are comfortable that that individual pupil has sufficient maturity to understand what it is they're requesting, so they're understanding in essence what their legal entitlements are, then it is the pupil who can make the request. Parents do not have a right to make a data subject access request for a otherwise competent pupil. Now, if you get the request in from a parent saying, I want my child's paperwork, then again, I'm afraid, simply from a relationship point of view, it's not appropriate, nor should you ignore it. You can either just bat it back with a, we need the child's consent or request, or indeed, if in other circumstances we were in school, you would go and have a conversation with the individual pupil, make it clear that this request had come in for their data, and see whether or not they were happy for that information to be provided.
Great, thanks, Chris. We've had a question here that if the teacher assessed grade, the centre assessed grade, is changed through standardisation, so when the final calculator grade is given, it's different. If a school gets a request in and it has been changed, do they need to send the teacher assessed grade, or just state the fact it has been changed? I'm assuming that will depend on the wording of the request itself.
Yes, but if they're talking about the assessment grade, then the likelihood is that's going to capture the assessment centre's grade that was submitted. Is not for a response to a data subject access request for the school to explain anything. That's not part of the data process, the data management process. It is simply to provide the information that is available, not about creating it or interpreting it or anything of that nature, simply providing whatever personal data that is relevant to that request.
Great, thank you. Another question around whether a student's number in the rank has to be included if there's part of a subject access request. And I suppose sort of building on that, if a student just asks for their grade, would you expect a school to also give them the rank order even if that hadn't been requested in the initial request?
That's a judgment call. First of all, your starting point is very much the request itself and how that is to be reasonably interpreted as to whether or not it would cover the grading. And the second is whether or not you feel that that makes any particular difference in terms of the context in which that request has come in. The Information Commissioner's Office has, throughout its guidance, sought to ensure that data controllers, schools in these situations, are helpful in the information that they're providing. Because if you are not given the information that is being sought, then it's simply going to trigger another inquiry and further time and attention. But again, you need to be careful that you're not just bombarding a parent, carer, pupil in response to a request with everything you have about the particular topic. Personally, I would leave it to answer the question, but that probably because I'm a little bit more pedantic than others might be.
Okay, but I suppose the point is that if a data subject asks for both their teacher assessed grade and their rank order, then you would need to provide both those things.
Yes, indeed. And to be clear, you only provide the rank order for that particular individual. You wouldn't identify who was ranked around them or the ranking of the relevant year group.
Great, thank you. So another question here around if a student requests a mock exam script marked that might have been used as part of the process, does that form part of the Data Regulation Act?
The requirements of the Data Protection Act exclude exam scripts from its remit, so that you would not, under any circumstances, under data protection and under a data subject access request, be required to provide an exam script. Whether you choose to share that as part of teaching and learning and part of genuine feedback and work with the individual pupil is separate to data protection. So that then falls under the discretion of the school.
Great, thank you, Chris. We've got two questions that sort of go together here. One is, does it matter who receives the request, whether it's a form tutor, a head of department, a curriculum leader, data officer, the head? And I think you've already answered that by saying any request should be considered.
Absolutely. The data controller is the school.
Yeah.
So anyone who is connected to the school that receives that request should be aware of the school's policy and procedure for dealing with data subject access requests, who the data protection officer is, so that the request can be channeled very quickly, given the timelines, to the correct people to pick up. And again, as I say, this is one of the difficulties where an inquiry comes into a teacher as part of a sort of separate conversation that may be taking place via email in relation to a particular pupil. And it's so easy just to miss the fact that within that email that's come in is a request for information that would satisfy the data protection requirements.
Chris, that perfectly leads into the next question, which is that a leader saying that she's aware of some staff who have already been asked a question by email by students, by individual email, asking for their grades. And of course, teachers have quite appropriately replied, well, I can't tell you this yet. I can't discuss that until results are published.
Absolutely.
what she's now asking, I think, is, given what you've just said, that could legitimately be understood to be a request, and therefore, do they now need to be followed up within the time period that you specified, which actually is longer than had they waited until results day?
Correct. So it is a valid data subject access request. The time limits are now running, and therefore the school will need to respond to those after the results day. Now, I'm not suggesting that the school takes advantage of the full 40-day limit that would apply to a request received before results day, but just to pick it up in the ordinary course as part of post results day activity.
Thank you. So I think it's a really key message here that, you know, if you have had teachers that have been contacted by students directly asking for their grades, even though the teacher might feel that's a fairly informal email, that could be considered a data request act, and you will need to act on that after publication of results. And it's probably worth leaders on this call making that very, very clear to teachers. They do need to refer that to whatever process you go through as a school for data access.
Absolutely. I'd say just to cover on that point, because obviously there's an element of strict compliance with what the requirements under the Data Protection Act are. In all likelihood, those pupils in such circumstances have absolutely no idea that they're exercising an access right under the Data Protection Act. If a response wasn't received within a timeline, or if it wasn't received at all, because on results day they will get the exam board effectively approved grade, and therefore issues around assessment process might simply just disappear out the window. So if no response came to that, even within or without the regulatory regime, the likelihood of a complaint or claim is probably minimal. But unfortunately, from an individual's perspective, there is a process that applies to that request. They ought to ensure that they're complying with that process.
Thank you. Another question here around the possibility that by giving a central assessment a grade, or particularly rank, another student's data will be revealed. Again, I think you touched on this, Chris, by saying when you give that rank order, you're literally given a kind of a number within that grade. So there's no reason, or certainly not no reason, you shouldn't be giving the names of students either side of that student. So in theory, there's no reason why that confidentiality should be broken.
Absolutely. It's you were ranked 14. That's it. You're not even required to say how many were ranked, whether it was 100, 150, or whatever. But obviously, we live in a real world, and anyone who's getting their ranking will be checking with their fellow pupils and seeing where they were ranked. So that information is going to come out in one way or another, but it's certainly not going to come out from the school in breach of their data protection obligations, or the request from Ofqual to be circumspect.
With that in mind, we've got one sort of question here, which is to say, I don't know the school's particular circumstance, but they anticipate getting a large number of these requests in August, and they're saying, what would be both the legality, but also a kind of the general advice around just simply publishing the teacher assessment grades and the rank order. Would that be legal, or would that breach confidentiality and data regulations? And would that be a good idea in order to avoid having to deal with all these individual requests?
Yeah, it kind of links into common custom and practice every year with schools who will publish in the local newspaper the grades that pupils are achieving in national exams. Mm-hmm. That itself has a confidentiality issue. It has a data protection issue. Strictly, if a school is going to publish in newspapers in that way, or indeed just on their website, or by circulating information amongst that particular year group, they need to have dealt with the prior disclosure obligations under the privacy notice. So the privacy notice of the school should say it is our custom and practice to publish the results once they have been achieved, or we may publicise test markings and other assessments. You need to check what the privacy notice says in terms of whether or not that kind of mass disclosure is already provided for. And again, given the exceptional circumstances, some of the language in a privacy notice might not cover. So in the ordinary course, if you were proposing to publish results, you would need to identify what your legitimate purpose was. If we were working on that it was in their interest to do so, as opposed to consent, then the fact that that hadn't been previously identified in the privacy notice is a potential breach. If they are waiting for consent, then obviously there's a massive logistic problem of trying to get consent of everybody before you do a publication immediately following results day. So it is a bit of a minefield, but if they ordinarily do it, it's going to be hard for anybody to complain. Ideally, as I say, schools are already materially compliant with their data protection obligations, and those kind of things are already covered under their privacy notices.
Great, thank you. So I've got a question here. I might read it out verbatim, which was that there's talk about the decision process being ring-fenced, so as not to put pressure or sway the rank grade process. It seems from your presentation this process and the evidence used to arrive at it can actually be asked for released by parents or the students. As in, it's not ring-fenced or protected. Is this correct? They can ask for details of the procedure and not just the rank grade arrived at. So I think this, Chris, maybe there's two things to cover here. One is, again, highlighting the difference between the FOI around the process itself and the data subject request that relates to specific data about the students, but also the fact that absolutely you can have, if you like, behind door, closed conversations essentially.
Yeah, absolutely. Ofqual guidance is that confidentiality is maintained until results day, and that's absolutely confirmed within both FOI and data protection rules. You can interpret it in the way that you need to ensure that you're not having to disclose the inner workings prior to results. After results, data protection subject access request regime works. They can access that information. There is no ongoing justification for not disclosing that information in response to a valid data subject access request. There is no statutory ring fencing of the decision-making process. That may come out, we don't know. But as matters currently stand, absolutely, there's a protected period up to results day.
Great, thanks, Chris. Question here, which again I think maybe you sort of touched on earlier, which is, will any emails between individual members of staff discussing grades have to be given if that's part of the request? And if so, should schools be encouraging staff to delete emails? Again, I think this comes on to the fact that deleted emails will still need to be given depending on your school's policy.
Absolutely, yes. So any email that passes between the teachers that is relevant. So again, we have to distinguish between whether it would fall under freedom of information or the data protection regime. So general discussions on methodology is likely to be freedom of information, but as soon as it starts to narrow and focus on an identifiable individual, it falls under personal data and will be disclosable as part of a data subject access request. Now, what that means is that if you have an email with 50 names in it in which you're discussing each of them and providing their assessments, then that email is disclosable in each and every situation. You're then into the area of redacting information that relates to others as part of a response to a particular individual data subject access request. So you would provide their grading, their assessment, and the relevant extracts from that email that relates to them, you would redact, cover up all the other personal data that's in there relating to others.
Great.
And again, it's not a case of cut and paste out. I'm afraid it's redact within the email itself.
Yeah, thank you. So I mean, the short answer then is yes, absolutely, those emails do count, and it's not as simply as just telling teachers to delete them. It entirely depends on your data retention policy and making sure it's up to date and compliant. Great. So a practical question here around does the time periods that you've discussed refer to the date of the request, i.e. we've already identified some that have already come in, or the first date, or the exam result date, the publication of results, or the first day of term? Presumably it's the date of the request, is that right?
The date of the request is your starting point. That's what triggers the requirement to respond. It's simply that if the request has come in before the results date, there is a particular extension to the time limit for responding. The start or end of term is not relevant to that process under data protection.
Yeah, and so what sort of follow-up question there is that obviously a lot of these might come in during the summer holidays, but there might not be staff to deal with them. Presumably, again, this is data laws. Centres, at schools hold this data. They have just got to find a way of dealing with them. Is that right?
Absolutely, yeah, absolutely. As I say, both the sort of earlier regulations, pupil information regulations, do still refer to school days. Freedom of information does still refer to school days, but they have default provisions. Data protection, I'm afraid it makes absolutely no difference as to when the school is open or closed. The time is ticking even during the summer and other breaks.
Thank you, which I'm sure is not the answer people wanted, but I'm very glad that you could offer that. I think I've been able to answer all the questions we've had through the chat. Mike from SSAT, have I missed any? Mike, you're unmuted.
No, I think you've covered everything.
Lovely. Thank you very much. Well, Chris, thank you very, very much for your time this afternoon. Chris is very kindly agreed to make all of these slides available, and of course the recording will also be available on the SSAT blog. So please do refer back to them, and if you do have any questions, then do be in touch through SSAT and through your SSAT relationship manager. Chris, have you got any final words or piece of advice for people?
No, as I say, I know there's an awful lot of concern. That concern arises out of the exceptional circumstances that we are in. The data protection regime, I'm afraid, applies regardless of those circumstances. Professional judgment, and I'm sure that the usual robust standards which schools are working to will see them through this process. So good luck with that. I'm waiting for my eldest year 13 results as well. So I'm holding on to my data subject access request, just ready for.
Yeah, brilliant. Well, thank you, Chris, and thank you to Wrigleys. And again, if you do have any specific questions, then please do let us know. But for now, thank you for joining us this afternoon. Please do continue to log into these SSAT updates, do invite your colleagues, and stay safe, stay healthy, and be alert, apparently. Thank you.
Thank you all.